Hello, this is social media attorney Mark Fiedleholtz, and welcome to my podcast, How Inadequate Social Media Liability Training Wipes Out an Employee's Personal Finances. Now, let us start by shattering two of the biggest perceptual mistakes employers make in their perception of social media. This perception, or misperception rather, leads to use of boilerplate social media policies and superficial social media law training that leaves both the organization and employees exposed to big legal damages, destroyed careers, and a total loss of the public trust. So here are the two biggest mistakes. First, you must realize that the US Supreme Court and lower courts view social media as an inherently dangerous broadcasting platform that gives unmonitored employees the viral power to permanently destroy a person's reputation worldwide. Now, contrary to popular opinion, therefore, any public or private employer, rather, who views social media as just a public relations issue instead of a high liability HR issue that impacts the constitutional rights of others is just setting themselves up for a multi-million dollar lawsuit, personal liability, and irreparable damage to their reputation. So that's one of the biggest mistakes. Now, here's the other biggest mistake. You are not set just because you have a social media policy and issued verbal warnings to your employees. And that's what a lot of employers think. So, since social media is a high liability legal issue, you can't just hand out a boilerplate social media policy and give employees verbal warnings. And it should be stated that 99% of social media policies from reputable policy services and associations were not written by experienced social media law experts like myself and have gaps. Courts quickly reject these type of policies as unconstitutionally vague and especially on First Amendment issues. Also, the organization has absolutely no proof in a lawsuit that the policy was enforced with outside expert social media liability training because they knew or should have known that their in-house attorney was not a social media law expert. Again, social media is a highly specialized field now. It's not just something any employment attorney or any general attorney can address. So, with this information as a primer, let me show you how your personal assets are exposed when you make a social media mistake and the reason why my online course and policy updates have become so urgent for hundreds of employers, private and public. I think the best way for you to understand how both decision makers and employees who make social media mistakes are exposed to having their personal assets wiped out is to give you a realistic scenario that occurs every day in courtrooms around the country. In this case that we're going to talk about, you have three people from the same organization who are involved in a high dollar discrimination and harassment social media lawsuit. The litigants are as follows: HR Director Martha Jones, Supervisor John Brown, and new employee Letitia Hemingway, who works under the supervisor. Now, you should know that obviously I've changed these names, but this is a realistic scenario. All right, so here are the facts of the case. As background, you should know that HR Director Jones and the in house attorneys made a determination that social media was a public relations issue, and it didn't warrant the hiring of an outside social media attorney to update their social media policies and training. But it was not really until the organization was engaged in litigation did they realize how wrong they were. All right. Once they fired an employee for social media policy violations, they finally woke up when their social media policy and training were being scrutinized that they were in big trouble because they did not meet new federal social media policy and training standards. In fact, it's very interesting that in most of my seminars and then online course evaluations, my participants had no idea that there were new federal social media policy and training standards. All right, let me give you more specific facts here. Supervisor John Brown was very angry rather, over a local Black Lives Matter protest. The supervisor posted numerous negative comments on social media from his personal social media accounts. One of the posts was a meme that the supervisor really meant as a joke. I mean, according to his testimony, he felt that it was just a joke, but it did end up going viral. Now, the meme was heavily photoshopped and depicted a picture of police using a water hose to disperse Black Lives Matter protesters. The meme had a caption saying, "It's about time these people took a bath. Now they need to clean up their attitudes." And again, as I said, the meme went viral, and of course, it created a stir at work because all the employees found out about it. Well, there was a new employee, Letitia Hemingway, who was a Black female, and she took great offense to Supervisor Brown's meme. She expressed her displeasure to other employees via her personal social media accounts. And an employee who received one of Hemingway's posts showed the post to Supervisor Brown, because obviously Supervisor Brown was not on the new employee Hemingway's friend list. All right, so moving on. Supervisor Brown called new employee Hemingway in for a meeting. He told her that her posts were violating the organization's social media policies and to immediately stop sending those type of negative comments to other employees. He also reminded her that his Black Lives Matter meme was free speech under the First Amendment, and he had a right to do it, especially because he was doing it on his own personal account. But her negative comments to other employees was not protected by the First Amendment. So a few days later, after the meeting, Supervisor Brown sent a post from his personal social media account to his friends list that he had this new employee, Letitia Hemingway, who took offense to his funny meme. Now, in the post, Supervisor Brown claimed the new employee fits the exact stereotype of an angry Black person who is incompetent at her job and seems to have serious mental health issues. And that's exactly what he said in his post to his friends list. At the end of the new employee Hemingway's 4-week probationary period, the supervisor gave Hemingway a low evaluation score and eventually terminated her services. The supervisor claims the termination had nothing to do with the post that Hemingway sent, but had everything to do with her performance. So weeks after the termination, Hemingway hired, and remember what we're talking about, the new employee who was fired, Hemingway. She hired an attorney, and a lawsuit was filed for defamation, retaliation, discrimination, harassment, intentional infliction of emotional distress, negligent social media training, and policies. A lot of times in these cases, they just throw the whole kitchen sink out and then just hope that most of them survive motion to dismiss. All right, let's move on. So, moreover, what I think is interesting in this case, and what you need to know is Hemingway's strategy, the plaintiff attorney's strategy in not only suing the organization, but Hemingway also sued both HR director Martha Jones and the supervisor who fired her, John Brown, personally, individually, in their individual capacity. Unfortunately, many HR directors and decision makers and employees, they just don't have a clue that they can be sued individually. They assume that they may have messed up, but they figure that the litigant or the plaintiff is always going to go after the deep pockets, which is the organization. And that's just not necessarily true, especially when it comes to social media, because you've reached millions, it's permanent. These attorneys flock to this type of stuff because it could be big dollar damages. And we'll talk about this again a little later. So it should be noted in this case that the HR department was unable to present any documentation at all that the organization delivered specialized social media liability to all employees, which is required under new federal standards. In other words, since you're dealing with a high liability issue, you can't just hand out a policy and give some verbal warnings. That's not going to cut it. You actually have to show documented proof that you gave outside social media liability training to all employees, because there's no way this can be done in-house. This is a specialized course, and your in-house attorney is not a 30-year plus social media attorney or digital media attorney like myself and trained over 100,000 people. So you don't want to walk into court saying that all of a sudden now your attorney, your busy attorney, is an overnight social media expert. So that's one of the biggest problems here, is that they just have no evidence of training. And by the way, even if you had a great policy, you still have to enforce it with training, because this is high liability issue. It's not just a public relations issue, as I said before. So now that you know the core facts of the case, let's address your personal liability exposure in a case with this type of fact pattern, because I can tell you now, it's not if this is going to happen, all right, it's when. It is going to happen. All right. If you don't get educated on these new social media speech laws, I've had over 30,000 people now. I can tell you with great authority is that you're going to lose every single penny in your bank account. And that is not hyperbole. That is the case. Because if somebody messes up, they're going to sue the organization and they're also going to sue you individually. Because remember, your tweet or your post or whatever it may be, your social media comments are going all over the world and it's permanent. So that's a lot of damage out there, right? So here's the reality check. Contrary to popular belief, most organizations will not pay for an employee's attorney when they are sued personally, and especially if their comments were off duty on their personal social media accounts. Often the employee must pay out of pocket for legal fees, settlements, and judgments. Social media cases can take years to resolve, and since social media comments can reach millions, as I said before, and create a permanent digital footprint, just the legal fees alone can destroy your personal finances. Now, the average settlement and judgment of a social media related lawsuit is around 500,000 plus. Since most social media cases involve intentional and malicious conduct, you got another problem here. Judges commonly award punitive damages to the plaintiff, which means not just actual damages, but punitive damages, which can be in the hundreds of thousands and millions of dollars. And this means that your personal assets will be attached to satisfy a settlement or a judgment. So, again, it's not a scare tactic, it's not anything crazy. I'm telling you, based on my 30 plus years of experience, what's going to happen here is that your tweet or your post goes out to millions. You can't get it off. It's permanent reputational damage. These are high dollar lawsuits, and they're going to go after your personal assets. And this is the reason that I have been so passionate about organizations to train everybody, because at least not only will it mitigate the harm, I believe, and when you're educating more employees, but now you have documentation to show that, hey, they messed up, the employees, but we did provide outside specialized social media education. Because remember now, plaintiff attorneys know that most organizations have a false sense of security that their boilerplate social media policy comes from a reputable policy service and association fully protects them in court. And this has been the biggest problem, is that you have good associations out there and good policy service, but you got a real problem. Either one, they only do like 2-page policies and just cite the minimum standards, and they really haven't updated these policies to meet the new federal standards. And who were they written by? Did you validate it? Did you check? Because I can tell you right now that 99% of these policies were not written by an expert like me. And I've gone over enough policies and rewritten them to know that they would have never survived in court. All right. So you don't want to deal with boilerplate policies and verbal warnings. It's the worst thing you can do. Now, most organizations also make the fatal mistake of under-risking social media as purely a public relations issue and only focus on marketing instead of social media liability training for all employees. It's imperative that your organization makes the shift from looking at social media as purely a public relations issue to looking at social media as a high liability HR issue that has a dramatic effect on people's constitutional rights. And if you don't do that, what's going to happen here is you're going to destroy your public image, and employees are going to face personal liability, and organizations are going to face big legal fees, and it's going to be an absolute nightmare. All right. Plaintiff attorneys always approve. I mean, this is one of the reasons they take these cases. They always prove, rather, that penny wise, pound foolish decision makers knew or should have known that their in-house attorney was not a social media law expert, and the need for outside expert social media liability training and policy updates by a social media law expert was obvious. I mean, they basically want to make you look like an arrogant, know-it-all idiot. And that's the game. All right. So I'm really hoping that this is resonating with you, because we have an urgent situation going on here. All right. Here's a twist that I want you to know too about these cases. Even if you have your own personal liability insurance, you still could be in deep financial trouble, because insurance doesn't cover claims where the conduct has been adjudicated by courts or other authoritative bodies as intentional and malicious. So you have to be careful with this, because maybe organizations will have pool trusts, or they could be self-insured in their insurance, but the premiums are going to go up and somebody's going to pay for it. And especially in the public sector, it's going to end up being the taxpayers, right? Here's another issue that makes this a problem: social media lawsuits. If you are looking for a solid affirmative defense to squash the claim, don't get your hopes up. Most social media attacks are directed against federally protected minority groups, which removes the thin veil of the qualified immunity defense in the public sector and triggers powerful state and federal discrimination laws in the private sector. You know, the Supreme Court back in 1998 handed down a number of cases where they said, look, if you have a high liability issue like harassment, sexual harassment in the workplace, or something else, you can't just hand out a policy. You have to enforce that policy with really substantive, in-depth training. All right, and that of course applies here. So as we move to the end here, in closing arguments, I could just envision the plaintiff's attorney stating that HR Director Martha Jones and Supervisor John Brown was grossly negligent in telling their employees to be brand ambassadors on social media without giving them the proper tools to stay safe on social media. They could compare it to giving a person the keys to driving a NASCAR race car that goes from 0 to 60 in 3 seconds. They know how to drive a regular car, but not a race car, and especially without proper training. So eventually, what's going to happen here is the uneducated driver will crash and suffer great harm. And that's the analogy they make with social media. You can't just tell them to be these grand ambassadors, and you're not going to teach them about defamation, libel by implication, core media law issues, copyright infringement, invasion of privacy. What I said before holds true. What the plaintiff attorneys are going to try to do by exploiting your boilerplate policies that you place blind trust on and your verbal warnings is they want to frame you as arrogant know-it-alls who could care less about their employees, right? Because you're not saving money. What you're doing is you're destroying careers when you don't take social media liability seriously, all right? So in the end, HR Director Martha Jones and Supervisor John Brown will lose their case and face financial ruin. What makes the scenario so sad is that none of it had to occur. If HR Director Martha Jones would have made my expert social media liability training mandatory for all employees, they could have mitigated the chance of this scenario playing out. And even if somebody did make a mistake, if an employee made a mistake, they would have documented proof that the organization complied with the new federal standards requiring outside expert social media liability training for all employees. And they would also have been able to prove that I updated their policy. And as a 30+ year expert, that means they did show foresight. And by the way, foresight is the antiseptic for negligence. Because if you can show that you had foresight, well, where's the negligence, right? Because that's one of the main components of negligence. So, all right, we've come to the end of the podcast. I hope this information was instructive in helping you understand the true risks of today's ever-changing social media landscape and why my online course and policy update programs are so important. Unless you have an in-house attorney who has over 30 years practicing digital media law, like myself, and has trained over 100,000 professionals, it's ridiculous and unreasonable to think your in-house attorney has the expertise like I do to deliver specialized social media liability training and policy development. It's just not fair to the in-house attorneys. Most of the in-house attorneys I know in both the public sector and private sector, very caring people, very bright. You can't ask them to be overnight social media experts because it just would look foolish in court. And of course, they wouldn't accept it either. All right. So you have to know that's why in-house attorneys nationwide have given me so much support, and they have actually made my course mandatory for everybody. All right, so I hope you immediately have all your employees register for my online social media liability course and allow me to review and update your social media policy and other digital media policies. So again, thank you for your time, and that's the end of this podcast.